In a big judgment, quite literally, the Supreme Court has upheld the validity of various provisions of the Prevention of Money Laundering Act 2002 by holding that all the provisions are reasonable and have a direct nexus with the object of the Act, that is, to combat the menace of money laundering. While the judgment runs into 545 pages, the key takeaways are: 1. Unlike FIR, the ECIR need not be formally registered. It is also not mandatory to supply it to the accused. 2. The twin conditions provided under Section 45, though restrict the right of the accused to grant of bail, do not impose absolute restraint on the grant of bail. Not just regular bails, but this section also applies to anticipatory bails. 3. The court has suggested that the feasibility of placing ED manual on the official website of ED may be explored. 4. The power of arrest given to high-ranking officials under Section 19 is not arbitrary. 5. The summon issued under Section 50 is in connection with the inquiry regarding proceedings of crime which may have been attached and pending adjudication before the adjudicating authority. It is not necessarily for initiating a prosecution against the noticee as such, and hence not violative of Articles 20, Clause 3 and 21 of the Constitution. 6. The inclusion of minor offences as schedule offence is reasonable, as the offences of money laundering are independent offences, and the persons involved in the commission of such offences are grouped together as offenders under this Act. There is no reason to make distinction between them insofar as the offence of money laundering is concerned. 7. Same reasoning has been applied to uphold Section 4 that makes no distinction between persons directly involved in the process or activity connected with the proceeds of crime and the other not so directly involved people. It has been held that the punishment under Section 4 is not in relation to the predicate offence but offence of money laundering under Section 3 of the 2002 Act, and hence valid. 8. The vacancies at the Appellate Tribunal must be filled, as otherwise the aggrieved persons have to rush to the High Court on every occasion, which is indeed avoidable. And last, whether the amendments to the Act of Finance Bill or Money Bill is a question already pending for consideration by a larger bench in another case. Hence, it was not taken up in this case. The most comprehensive point-wise breakdown of the verdict can be found on the SEC online blog. Do check it out.